conjunction with what was said in the previous session and some of the other sessions that will be in the legal sessions, lawyers can be your friends, but you need to tell them what you want in order for them to tell you how to do it, as opposed to having them come to you after the fact. Robert?
Thank you, sir. Are there, just a show of hands, lawyers in the room? Any other lawyers in the room besides myself? Okay, good. Now, show of hands, how many people here hate lawyers? Okay, let's get this out of the way right now. My profession serves a very valuable, useful purpose. We act as a giant vacuum and suck all the assholes out of everyone else's professions and into ours. So, now that we got that out of our way, we will talk about a little history, computer network defense. We're going to go over some of the computer crimes and prosecutions that happened in the last year, some of the key issues, the precedents that have happened since this last conference, some issues in computer and internet security, and I'd like to talk about the materials that I've given you are on page 207 if you want to follow along. Now, my slides have changed a little bit, and that was thanks to the Supreme Court coming out with the Grokster decision recently, so my slides will be a little bit different on that. And I found out that when you are here in Vegas, you can't be here without giving out prizes. And I also understand that a couple things. The only thing standing between you and lunch is me. And possibly the only thing standing between me and a positive, favorable evaluation would be you. So I either need to get you to lunch quickly if that's important to you, and or bribe you. And so I can't take credit for this, but one of the last presentations I did last week at the Army JAG School, the Navy lawyer, Mindy Seifer, she came up with this creative way to, when she asks questions, or if I have trivia and you answer, I get to throw, Snickers bars to you. Now, being a lawyer, I'm not liable for taking out anybody's eye on my throw if I don't get it to you, but there'll be some trivia, and it doesn't matter if you're right or wrong, and that'll be my bribing technique to get you going on that. Now, when you are talking, I've been to Black Hat 2 years before this, and I wanted to make sure when you're talking to an audience, you address the issues that that audience wants to hear. And clearly Black Hat is a group of IT network security experts, security professionals. In my realm that we're talking about, obviously, here we're talking about policy law, things that are going on in computer and internet security. Now, when I hear people speak, I like to know their background so I can understand how to interpret what they're saying. I'm being followed by, later on today, by Jennifer Granick, who works for Stanford and is a defense counsel. You pretty much know where she stands as a defense counsel on things. I work for the government. I work for the Army doing this, which kind of doesn't tell you a lot about exactly where I stand. Again, my name is Robert Clark. For those of you who don't speak English and speak code, my name is right there. And I have to put up my famous little disclaimer because my bosses want to make sure you understand that any errors in my presentation remain with me. I don't speak for Department of the Army. I don't speak for Department of Defense. I'm speaking here in a personal capacity. And as we go through the stuff, we're going to, again, look at a lot of information, some precedents, key things, arrests, prosecutions. I apologize if I've missed anything, any key arrests or indictments possibly out in the room. If I missed your arrest or your indictment and I don't mention it, I apologize. I've been very busy finishing up my community service. Picking up those cans along the side of the road takes a lot of time, so I've been out of my office doing that. So I apologize if I missed something key from there. My background, I'm an undergraduate of the University of Michigan, and I went to law school at Michigan State. What does that tell you so far? It tells you that during football season I follow Michigan, and basketball season I follow Michigan State. More appropriately, my Army background, I've been in the Army for 15 years. I've kind of done it all. I've been a prosecutor. I've been a defense attorney. The last 3 years, I've had the privilege of being the legal advisor to the Army's Computer Emergency Response Team, doing network, computer operations, computer network operations. What's this tell you? Not a whole heck of a lot, but it probably tells you that I'm a government hack, from one aspect. Again, I could be any kind of a government hack. During the 80s, if some of you were born at that time frame, if you don't, this was Ronald Reagan. He was the president during the 80s. A little history lesson here. I was a nice little Republican. When Ronnie snored, I snored. When Ronnie rolled over, I rolled over. Then we went into the 90s, and this guy showed up. And what that did to us, well, it took a bunch of us nice Republicans and forced us towards the center. And what does that mean? Well, it still tells you I'm a government hack. However, if you can see that, that's the front page of the Constitution of the United States. A pretty neat document. If you go back to your high school civics book, it's about 14 pages in there. And the complete operating instructions for a country of 250 million people. Now, my manual to use my Panasonic laptop is 5 times as long, and really only I can read it one person at a time. This is a pretty good document, and it gives us our basis for a lot of things that we do, even in computer and internet security law. What's not here? Well, I'm sorry, super secret things aren't here. Area 51, stuff like that. Sorry, not my area, don't know anything about it. Basically, what's here? Hopefully an understanding of computer network defense. And it's amazing how not only government computer network defense, but computer network defense for ISPs or corporation all interrelate because we all use the same authorities when we're really doing these things. Talk about some of the legal principles going on in our field. And I've got, of course, my final disclaimer. You know, everything I've seen in the Black Hat presentations and the books, I'm not your lawyer. I didn't go so far as someone actually put in there, this does not establish an attorney-client relationship. What a paranoid profession I am in. It's not like you're in the elevator with a doctor and he goes, oh, I'm a podiatrist, and you go, oh man, I got this problem in my foot, and he's like, whoa, 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 this doesn't establish a doctor-patient relationship. I can't tell you anything about it. But we are a paranoid profession, and so basically, I'm not your lawyer. We're talking about legal principles here. Legal advice deals with risk management. You know, when we get into the hot topic of active response, you know, the question becomes, if I see a script kiddie kind of, you know, hacking at my laptop, do I want to smack him back and take down his machine and melt his hard drive? Well, if it's a script kiddie, I mean, you know, you may want to have a lawyer on retainer because obviously that's a violation of the Computer Fraud and Abuse Act, and, you know, you'll be okay. But if you see more of a, you know, a zero-day exploit comes through that gets past your logging systems, your security systems there, and you're thinking, damn, I'm going to smack this one down, and it happens to be like Citibank's Malaysian server, hey, go ahead, by all means, have fun, have at it, but you better have like Jennifer Granick in your back pocket to take care of that. It all deals with risk management. How much do you want to come up on the radar screen for the actions and the things that you're going to take? There's one thing I think I want to touch on before we go further, and that is the problem probably many of you face when you do talk to lawyers. I mean, you hear us say, it's a new area, it's unsettled, there aren't very many precedents. So I thought I want to leave you with one thing, if I can leave you with one piece of advice that pretty much no lawyer will disagree on whatsoever, so you can go out of here saying, hey, I finally heard something from a lawyer that said, you know, this is definitive. Wear sunscreen. Okay, it's a scientific fact that the sun causes cancer, so if you wear sunscreen, you'll live longer, you won't get skin cancer. So let's begin. When I got accepted to do this, I went back and used my legal research, and I said, you know, you're not anybody until you're recognized by a court. And I said, when did courts discover the word computer? And so I did a search, and you can see the numbers there when we started really getting active with computer. Then I said, okay, well, what's the first case? Well, what I found was a case called Comptograph, and it was a patent case over the construction of a calculating machine way back when. And then, you know, sometimes you come across a great name, and In Re Spitzglass. You know, anybody with the name Spitzglass is a great case. And this was a calculating device comprising 3 coaxial rotatable discs, 3 pinions connected to said discs respectively, gear segments movable about fixed pivots, and meshing with said pinions and linked to pivots to said segments, and pivotally interconnected in such a manner that angular movements of 2 discs in direct proportion to the 2 quantities will cause movement to a 3rd disc in proportion to the product of those quantities. Now, if anybody understands that, please come and explain it to me. But this was basically a calculating machine, and that's the first one that I found. Sperry versus Bell Lab is where you're really getting into, basically, and this is, you know, you have fun with this because I was lucky enough to meet Mr. Morris, or Dr. Morris, last night, where you start getting into cocktail conversation. Good old J.P. Eckert and John Markley making the computer, and they got in a suit against, they represented Sperry, and Bell Lab said they invented the computer first. To make it definitive, the IRS got involved. And back in 1952 and 53, apparently Mr. Eckert was deficient in his taxes to the tune of $264 and $459, and they held that he invented the computer and they owed him, he owed them that money. And that's what Sperry versus Bell Lab found out in 1962. The interesting aspect that I point out here for you and for us, this was back in '62. It was a paper case, which I've dealt with before, and that means no witnesses. Everything's going to be done by affidavits. It goes into the court and is explained to the court in that fashion. This case had several hundred exhibits and affidavits. They went to a warehouse to inspect the computer, which was the Electronic Numerical Integrator and Computer, and held that good old J.P. Eckert did actually, in fact, invent the computer. You've got to take this very difficult area and break it down to a level that both lawyers and judges can understand it. And we're going to actually see that in a little bit on a case where a judge didn't understand it, and he wouldn't accept a guilty plea, which could be very important for myself and a client if I'm in front of the judge. Hacking. You know, hacking, you had the 60s. MIT emerged with the hackers there. They borrowed the name from people who actually hacked electronic trains to make them go faster and better. Imagine that. In the 70s, you had good old Captain Crunch and phone phreaks when you found out that the whistle from the Captain Crunch box actually blew the right frequency to get free telephone calls. Esquire magazine publishes how to make the little blue box, and we've got a bunch of kids doing it all over the place. In the 80s, you've got hackers' message boards coming up, which Sherwood Forest, Catch-22. Hacker groups are forming, Legion of Doom, Chaos Computer Club, and of course 1983 gave us War Games and Matthew Broderick. In the same year, a hackers group called the 414 Gang, which was the area code they traced them to, they broke into some 60 computers on a 9-day spree, including Los Alamos National Laboratory. In 1984, Hackers magazines make the scene. You've got 2600 in FRAC, and again, this is giving tips just like the bulletin boards were doing before. 1986 was great. You got the nice Computer Fraud and Abuse Act. Ironically, in '88, Mr. Morris's son, Dr. Morris's son, decided to test that, and as you know, he released the worm that propagated around. In the 90s, good old Mr. Polson, who now freelance writes, decided, no sense paying for a Porsche. I might as well just hack the radio station and let me win 2 Porsches for myself and my friends. He decided to do 5 years, and the first DEF CON conference shows up. 95 had Mr. Minnick, caught with 20,000 credit card numbers. Again, he goes on to fame. And Vladimir Levin, a Russian cracker, siphoned $10 million from Citibank, and he decided to do 3 years. And at least they say all of the money was recovered except for about $400,000. 97 gave us AOL Hell. 98, you had the Cult of the Dead Cow releasing Black Orifice. And in the year 2000, I know I'm an old fart, but most of you were around for that, so I really don't have to cover that. In the movies, you got basically, and again, if I miss something, famous uses of computers going from good old HAL in 2001 down through, I didn't realize this, but my pay-per-view is playing Hackers. I didn't realize Angelina Jolie is actually in that movie. That's a little Trivial Pursuit. My favorite computer of all times, the Governator and the Terminator series. And just saying where we've been from basically War Games to now, you had artificial intelligence being a mainframe, and now it's this really cool plane that apparently flies for the Navy. That's where, at least in the world, we've come with artificial intelligence now. Now, can anybody name what movie this particular computer was used in? Who said it? Okay, let's see, there's the shot. Oh, hey, it was a fastball. Watch out. Yes, it was. That's good old Matthew Broderick and Alex Sheely having fun with their War Games computer. This is an interesting aspect, the Authority for Computer Network Defense. Whenever you've heard your friends say, he who dies with the most toys wins, that's basically what we're talking about here. You're allowed to get as many toys as you want. It's property, and you're allowed to get as many as you want, use them freely, uninterfered with by anybody else. And that is the common law principle for property and personal property. And you're allowed to exclude anyone who's interfering with it. It's called a trespass to chattel. Now, you have to be in a place where you have the right to be, you have to use reasonable force, and you also need to know where your target is, who you need to keep from interfering with your property. That's kind of the key thing for our area when we start talking about an active defense. Again, as I mentioned, that's the trespass to chattel. Now, Intel versus Hamadi is one of the prevalent cases that kind of sets this legal principle out in terms of defending your system. It's a great case. It cites a lot of other cases, and it's talking about what you can do to defend your computer system. Good old Mr. Hamadi used to be an employee of good old Intel, and he founded basically the former and current employees of Intel, Face-Intel, and he sent out 6 mass emails to, yes?
I have a question. On your last slide, you were talking
No, this is what we're talking about here is basically what's called a common law doctrine, which is recognized in federal courts and in state courts. Now, say if I'm in, DC or Virginia and you're in New York and I've got a Porsche and you come down and decide to borrow it and go off driving in it, okay, and you damage it, I can sue you for the damage for taking my car. Now, I can choose where I live, Virginia, I can choose New York where you live, or I can go to federal court and do it there. And it's a common law doctrine in terms of trespass to chattel, recognized. And that's where you see a lot of things have been codified for that. Now, under Virginia law and New York law, I probably have criminal statutes that codify the taking, the conversion of property is what it is. In the civil world, in the civil law, I have both civil codification of the laws, and I should pay you. I should actually, thank you for taking me to my next level. Oh, bad throw, but he'll get it. Absolutely. You can always pass a statute to change a common law doctrine or to modify it. We see that a lot in torts practice and negligence practices. In this particular case, when we're talking about a common law, this is the evolution of where our codifications of these laws came in, and you're moving me in that direction on that. And this is simply, in this particular case, Intel versus Hamadi, the big thing was he sued and Intel wanted to get an injunction to stop him from sending all these email messages. And the lower court granted the injunction, said, stop doing it, you're breaking the law. Well, the Supreme Court of California came in and stepped in and said, wait a second, the uncontroverted evidence here is there's no damage to your system. So if you take my Porsche and drive around with it and bring it back and you haven't damaged it, I've lost the right to have it. I've been deprived of my property, and maybe I wanted to run up to 7-Eleven and get a Slurpee, and oh my God, now I couldn't. What's the damages for that, Not much. All right, so I have to still suffer some damages to sue you civilly for that. And that's what this case said. The Supreme Court of California said, there's no damages. The uncontroverted evidence is, you said your system slowed down a little bit. And they said, whoa, my damages. I got techies running all over the place trying to figure out how to block this. We spent hours doing this. That's their salary. I spent thousands of dollars preventing this. Yeah, that's true you did, but that's not the damages we're looking at for this particular case. Now, interestingly enough, a little bit later on, you had basically the case of Register.com versus Verizon. And I apologize, I do not believe I've got that in here because I threw it in here recently. And this particular case, if you are so inclined to find them, it's Register.com versus Verizon, V-E-R-I-O. And you can do searches on the web, and obviously you can find everything. In this case, the defendant and the plaintiff is using search robots to go in and do data queries against the system. And it cites several different cases, including eBay, that said, yeah, your system wasn't damaged, but if this information gets out and everybody starts doing these queries, it's going to really slow down your system and bring it to a standstill. So we are going to grant the injunctive relief. We are going to block them from doing it. So again, this was the aspect of saying, okay, trespass to channel, I can defend my system. Now, taking us where you decided to take us, and that is to the codification of these common law doctrines. Most of the laws and things that we do are based on what's called common law. That's out of Old England. Thou shalt not kill, thou shalt not steal. And so what we've done is we've taken them and written them down into the code. Now, for me, personally, I sit there and I follow good old 10 U.S.C. 2224, which tells Secretary of Defense, you will defend your computer system. Great, thank you. I've got it in law now. I don't have to worry about trespass to chattel. For the Computer Fraud and Abuse Act, that gives you a civil remedy if someone hacks your computer to be able to sue them to say they hacked my computer, I want damages, yet if you can prove your damages. Under this aspect, we're going to get into kind of the Electronic Communication Privacy Act and the pen, register, and trap trace devices. And we'll get there in a second. Let me keep cruising. For my purposes and what I do, the Department of Defense Computer Network Defense is run by Strategic Command in Omaha, Nebraska. A wonderful place. Try going there in January, February. It's great, very cold, winds rushing down the plains. That's Oklahoma, but it's Nebraska too. On this, they coordinate the defense of Department of Defense Computer Network Defense. What is our computer network defense? All right, this is the aspect that kind of confuses people. It's multiple disciplines. A lot of people doing it, bringing their authorities to do it together. It's not just one person. And it's actions within my computer system. That's kind of the definition of computer network defense. And we'll find, when you look over at companies, Chrysler, Ford, GM, sorry, I'm a Michigan kid, so I kind of go with the car companies, ISPs, AOL, Yahoo, it's the same thing. It's actions taken within your network to defend your network. Now, as I mentioned before, there are multiple disciplines, multiple players who bring their inherent authorities into computer network defense. They are your network operations, your intelligence, counterintelligence, and law enforcement. Well, what do I mean by that? All right, I've got someone, I've got a guy running down the hall, comes knocking on my door, and he's like, Joe Bob's computer sensor just popped up pornography. Okay, wonderful. So I pick up the phone and I call my cops. Joe Bob's computer in my organization that's supposed to be defending the network just popped up pornography. What's the first thing they say? Is it child porn? Pardon me? Yeah, if it's not child porn, we don't want to touch it. Okay, so now I've got a violation of a use policy. Well, that's a network operations job to remedy that. And it's kind of the commander who runs and owns the system to say, I've got a use policy violation, that's where we're going. All right, one event, porn popping up. So I go and I look at it. Hey, it's child porn. Same event, but now law enforcement takes the lead on it. They have the authority to come in and take over a criminal investigation for child pornography. Same thing that private companies have. Okay, they have acceptable use policies, and once a crime's been committed on the computer, they can turn it over to the cops. Now, again, it's all notification if I want to notify the cops about it. But it's an event that can be handled different ways. But we all bring our different authorities into it. And with a private corporation, you've got, again, systems where you're law enforcement. Now, in the Army, I have law enforcement. They belong to the Army. They work independent of everything I do, and they have their own general that makes sure no one tells them, I don't want you to investigate that. That was some of the abuses we had in the 70s and the 80s. They're independent. They conduct their own investigations. Now, what does a private company have? Well, they can hire private investigators to do investigation into a computer network breach. But again, at some point in time, if they want to, they will work with law enforcement, FBI, to resolve that. Now, for me, being in the Army, and every DoD entity has these different regulations, we follow the service provider exception to do computer network defense. Service provider exception is an interesting aspect. It comes out of the Electronic Communications Privacy Act, and what it is it's an exception. It's not what I call positive authority. Positive authority is my statute up there that says you will, Secretary of Defense, you will defend the network. Well, that's great, thank you very much, but it doesn't tell me how to do it. And same thing for private companies. You've got the authority to defend your network, but it doesn't tell you what you can do. Now, this exception allows you to monitor your network in the normal course of its conduct to protect the property. Now, this is an exception to ECPA, Electronic Communication Privacy Interception. It's the same for private organizations as it is for me. It is not a criminal investigation privilege. Again, it means if you're monitoring your system and you intercept communications coming through, FBI is not going to pound on your door and arrest you for doing a wiretap. So the exception, yes.
Okay, I had actually packet captures for somebody who was trying to break into a network, and the FBI says, okay, you got great evidence, we cannot use it to prosecute somebody because they can turn around and claim that you're violating the wiretap act.
Yeah, that's.
And I never, can you explain that?
Yeah, no. No, I can't. Because again, taking it right back to the common law doctrine, it's my network. I have the right to consent to monitor things coming into my network. Now, as I mentioned, it's got to be a substantial nexus between what you're monitoring and what you're sniffing. And, God love them. I love my techies. I wish, it's that classic, it's chic to be geek. I wish I had more technical knowledge and I dive in and read as much as I can. And whenever I talk to my techies, it's the question of, well, what can you capture? And, and the little smile comes on and it's like, every packet. And you're like, every packet? And it's like, every packet. And then, of course, the next question is, who the hell is going to read it from that? So you're allowed to have your system set up to monitor your network, to defend your network. Again, you're putting in the latest exploits. You're putting in the strings that happen, you're blocking ports. You're blocking IP addresses that you've seen come in. That's normal network defense. So the fact that they're saying he's going to turn around and say, hey, you violated ECPA, I'm not going to go with this. Here's the fun aspect. Here's, again, cocktail information for you. If I intercept and I violate ECPA, the Electronic Communication Privacy Act, and I intercept your traffic illegally, and I violate the Electronic Communication Privacy Act, that evidence still comes into court. There's not a suppression remedy when I violate the Electronic Communication Privacy Act. Now, this is the fun aspect. The Fourth Amendment, if I'm a system administrator and a cop says, getting ahead of me, well, I might as well knock off this case. You're sitting there doing marijuana and ecstasy, and oh my God, the person's writing 17 pages of emails about, oh God, I don't want to face your analysis. If I pee, they're going to catch me. What should I do? And a cop comes into me and says, system administrator, check that computer, find all the emails dealing with criminal activity, and I go in there, I pull them off, go, here, officer, go, have a great day. That's a violation of the Fourth Amendment. I just searched that computer for the cops, whether it's you, whether it's the Army, you just search for the cops. And you can't do that. You can't act at the directions of the cops and start searching a computer. That's a violation of the Fourth Amendment. And in this country, back to my little Constitution, the operating instruction for 250 million people, we think that's a pretty good thing. I don't want you searching my computer without a warrant. Contrast that to workplace misconduct. Okay? Again, I own my computer. And we're going to have cases that talk about this. Now I think my employee's just kind of, he's surfing porn, and I need to look at his machine to see if that's a violation of my acceptable use policy. And as I go and look on his machine, boy, he's got 4,500 images. Now I got a crime. Now I turn that over to law enforcement. I can do that. I didn't go searching for it as a law enforcement. I had no relationship with law enforcement. So now I go, I find it, and I turn it over to the cops. I fire his ass, and I say, see you later. Don't let the door hit you on the way out. Oh, by the way, those two guys standing there with handcuffs, they belong to FBI. Have a nice day. All right? So there's a standard there in terms of how you monitor and what you're doing in terms of whether that evidence can be used. And again, you've put me ahead of myself, so we'll be saving time. And that's what we're talking about when you're doing this. Notification and banners. All this law depends on your notification, your banners, and your computer use policies. All right, trivia time again. I can see you're really upset. You sit down, take a stress pill. What movie is this from? Who said it? Where am I throwing? All right, we'll just throw out there. It is Hal from 2001, who became operational on, what was it, August 12th, 1990? No, 12th of January, 1992. Talking about privacy in the workplace and things you can do. Good old INRAE Asia Global. Okay, this is dealing with email, and it deals with a bankruptcy. Your 5 insiders are your principal deputies or principal operators of the company. It's going bankrupt, and they communicated with their lawyer on their email servers. The trustee in this bankruptcy proceeding finds out about it. So what does any good lawyer in a trustee proceeding do? He files a subpoena to get all of them. The insiders say, ho, time out, attorney-client privilege, I'm not going to give it to you. And they said, well, the trustees moved to the court to say, no, I want these things. And the question becomes, do you have an expectation of privacy in your email? The classic case that deals with this is O'Connor versus Ortega. And it's a Supreme Court case that goes back and looks at several factors in terms of what gives an employee an expectation of privacy at work. And for this particular case, you're talking about what's the policies that are going on there? Does the company monitor the system? What's the third party's rights to access them? By the way, this goes to like your office space too. If you share an office with somebody and the cops come in and say, hey, can I look in this office? And you're gone at lunch because you're having a marijuana cigarette and that's what they're looking for. And your colleague says, yeah, come on in, take a look around. That's not an illegal search. They just got consent to search the office. Now you lock your desk drawer where your stash is at. Well, no, they can't sit there and open the drawer, but if they're smart, they're going to have their little dogs with them, and what's the dog do? Well, the tail starts wagging, and they start scratching at the desk drawer. And the cops say, okay, now I'll get my warrant. These are all determined on a case-by-case basis based on the facts that you have there. Now, this particular case of INRAE Asia looked at a lot of factors and talks about a lot of different cases and use policies that were out there. You're talking about employers who have announced the policy to their employees. You're talking about having a handbook that explicitly warns users that they'll be monitored. So these are all things that you look at when you're determining whether you have an expectation of privacy. I like this case because basically the lawyer for the 5 insiders testified, the corporate counsel came up and said, emphatically, we didn't have a policy, we didn't tell anybody. we allowed personal use, and so there's no way that we had a policy or anything that would, limit their expectation of privacy. Amazingly enough, all 5 of the insiders gave the exact same affidavit to the court. It was uncanny that they all said that they didn't know about anything and listing it right down. Now, as you can imagine, the trustee, wanting to get these things, disputed it, and they had 2 policies. They had an email messaging policy, or a corporate email policy that said anything transmitted through here is owned and operated by the corporation for the sole purpose of the business. And I think a lot of you have seen these words. I mean, we've all seen these in the banners that says official government business, sole purpose of the business. And they had a messaging policy that basically said the same thing. Again, you grant the monitoring the system, we're going to monitor the system, and read together, both these things show that there's no expectation of privacy in this. Well, here's the court. The fun aspect, the court said, I don't have enough evidence to determine this, whether it waives the attorney-client privilege. Didn't even really touch on your expectation of privacy, went off on a different direction and tangent. But the fun aspect of this is it laid out several of the cases that dealt with your expectation of privacy in the system. Bornitsky versus Williamson. I like this case because it's it's a defense contractor, and it shows the brilliance and the great interaction and working of our government. Bornitsky represented himself, and whenever you represent yourself, we love these cases. I clerked for a judge going through law school, and it seems that everybody who represents themselves, you've heard it. Any lawyer who has himself for a client has a jackass for a client, and it's true of anybody who kind of represents themselves. It's fun to watch, and a lot of fun things can happen. Bornitsky was hired by Raytheon, and he comes on board, and he applies for his job, and he signs the acceptable use policy. Plus he signed, hey, I'm going to let you do a background check. So they're doing the background check, and during the background check, it turns up that at SMU, he was arrested a year after he had left there, still using their computer system, so he's charged with a little trespass. Nothing big, but kind of a warning flag, something bad's going to happen. And while this is going on, government does what it always does. It gives out an interim security clearance. Now, gotta love them. I had them. You give them out, that means you've got access to everything. So he gets his interim security clearance, and he starts parking his van behind the building. And employees start reporting to the security officer, he's running a power cord out to his van behind the building. And he's sleeping there at night. And he comes in and works at night by himself. And again, this is, the company's L3, but it's the predecessor to Raytheon. So, some warning flags should be coming off. Going back to my employee misconduct lawful search by cops. All right, the security officer who works for the company gets these reports. I've got employee misconduct, violating my policies. I'm going to start looking into it. And he downloads the guy's entire computer and finds out that he's having some contact with some foreign nationals that hasn't been talked about before. So basically they tell him, hey, you're out of a job. Now he does what anybody else does. Can I clean up my desk? Sure, go clean out your desk. We'll go with you. And they go with him. He's cleaning out the desk, and as he's going down the stairs, he breaks into a run for the front door. Security personnel stop him. They call the cops, search his belongings. Yes, he's got classified documents he's walking out the building with and floppy disks. So that's a criminal matter. But we don't care about this because Mr. Bornitsky is suing the company civilly for the interception of his emails and the download of his computer. And basically, the court said, you've got to be kidding me. Mr. Bornitsky, is this your signature on the document? Yes, it is. Did you agree that they could monitor your system and read your emails? Yes, I did. What's your problem? Well, I wanted a job. They wouldn't give me the job unless I signed that. And they twisted your arm how? You couldn't go someplace else and work? And that's what the court said. You consented to this workplace, again under O'Connor versus Ortega, you can search this, no harm, no foul, thank you very much, don't let the door hit you in the ass on the way out. So interesting aspect again, going with a workplace with policies in place, signed by the employee, and you can monitor the network. If you're running an ISP and you're giving to the public aspect of this, this was an interesting case. Whenever cops go to an ISP and want to get information, they have to come with what? An order. Ah, what the hell? Who said that? All right. Can you tell me what the letter is on it? what the letter of that order is, what they call it? Anybody? Bueller? Anybody? It's a D order, is what it's called in the fun little vernacular. In this particular case, this individual went to an ISP and said, I want some information, some subscriber information, and they got it. Well, then the U.S. attorney 2 days later went to the court and said, hey, I need a D order for getting this information. And the court said, what are you talking about? You can't retroactively get a D order to give for information you already got. The statute says before you get the information, there are clearly things you have to do ahead of time. And they said, well, wait, I was dealing with a kidnapping, and therefore I had to go get it. And basically the judge said, stupid. There are provisions for emergencies under several different laws that say you can go get this information under that, citing the emergency and getting it. I'm not going to give you a retroactive D order to validate what you just did. Now, what does that leave our friendly little U.S. Attorney's Office facing? Well, that's the next one. Friedman versus America Online. This was an interesting case from the aspect of it started in Connecticut, goes to Virginia. And basically what we've got is two detectives, Young and Bensey, who fax a warrant to AOL to get some subscriber information. They basically didn't present it to a judge, so it's kind of missing the judge's signature, which is rather important. The detective, Bensey, I guess is kind of important. He kind of, I guess, thinks a lot like I do. So he signed for the judge and the judge's signature. It's a small problem in this particular case. Mr. Friedman noticed that, and so he sued both America Online and the detectives up in Connecticut. And the interesting aspect is, right off the bat, AOL is dismissed from the case in Connecticut. Terms of service, if you're going to sue me, you must sue me in Virginia. Bye-bye AOL. So now we're stuck with Young and Bensey up there, and they said basically to the judge, look, when we sent this to them, they weren't, it was a request. They weren't required to give us this information, so they made the mistake. Why should we be at fault for their mistake? Please dismiss us. They've got deep pockets in Virginia. Have them go that way. And the judge said, are you guys really that big of assholes? It was a 5-page document, warrant, affidavits. Anybody looking at this is going to say, this is a requirement. Then the fact he says, they've got 4 people at AOL who get these warrants that come in from all over the country. They get 1,000 a month from several different jurisdictions. I'm not expecting them to be able to be lawyers and figure out exactly what's going on with these things, although they did take it to the legal department at AOL. So no, anyone in the world would see this was not a request, this was required. And oh, by the way, Congress set this up so both the cops and the corporations or ISPs are both responsible. The fault of one does not relieve the fault of the other. So thank you very much. Open up your checkbooks and write Mr. Freeman a check. So now we go to Virginia. And in Virginia, AOL saying, time out, okay? I get 1,000 warrants a month. All right, and now, again, this was an interesting aspect of this one. This case arose from, apparently there was it's a campaign case actually out of the town of Fairfield in Connecticut for the first selectman. Now, in an earlier campaign in 2001, 2 people are going against each other, and one of the popular campaign slogans was "Go John, Go Away." And it was from this gal, Mary Carroll, and she was a Republican candidate. Well, when she ran 2 years later, her opponent in this particular case sent an email out, go Mary, go away at AOL.com. Her office got it, and they thought it was harassing email. They gave it to the cops. The cops thought, oh, this is harassing, so they went and got the information for this. So that's kind of how this all happened. They got the subscriber information from AOL and released it to the campaign. And of course, the campaign being any good campaign, they released it to the press. And this poor SOB up there said basically he had subject ridicule, he lost his real estate business, couldn't do anything, so he's suing everybody on this one. And AOL said, you know, we got this defective warrant, it's not our fault. We have a good faith basis, which is accepted in the law. If I get a warrant and I rely on it in good faith, then I shouldn't be held liable for it. Well, the judge looked at it and said, yeah, I understand you get 1,000 a month. You did take it to your legal office. You did look at it. And oh, by the way, if you look where it says judge's signature, while you can't read the detective's name, the letters D-E-T are right before it. How many judges do you know with the first name of Det on this? So they said there's some facts that are in controversy here, and this case was basically what's called a summary judgment case, which is where I just go in and say, there are no facts in issue here, I win, judge, and they denied the motion for the summary judgment and said, no, it is your responsibility to make sure that these are good warrants. I know you get a lot of them, but again, you have to make sure that you're on track and you're looking at these things to make sure they are compliant with the law. All right, what movie is this from? I know I'm not giving you a lot to go by. Where was that? Outstanding. That was, giving me a little coup, but, there they are. That was darn good. I'm impressed. I would have gotten that, and I did the slide. All right, U.S. v. Long. This is the case we talked about earlier that deals with the use of marijuana and the specifically searching at the behest of the law enforcement. I put the first one up here because it's a hit on the system that I operate in, the military justice system. Both these cases, U.S. v. Long and U.S. v. Maxwell, are cases that deal with privacy and computers. And in a West Virginia case, in a Western District of Virginia, the court cited to the military case. And basically the judge there said, get out of my court. Don't cite to military cases. They have no relevance in this court whatsoever. So whenever you get slammed like that, it's kind of an interesting thing to take note. But I also point that out to say that's where this case is going next. This is a military case, U.S. v. Long, and our hero in this case, she was using ecstasy and marijuana, and the cops came in and searched her computer specifically for law enforcement purposes. And the judge said, look, you have a banner there. It says this computer is for official government use only. You can use it for minimal purposes, to sit there and email your honey, and apparently to email about your marijuana use, but it is for official government business only. Now the question becomes, does that waive your Fourth Amendment right to having cops come busting down the door and start searching? When I first read this case, the big thing with the Army is, I'm not doing anything illegal today, at least. So if the cops want to look at my computer, I kind of give a rat's ass about it. So I don't believe I have an expectation of privacy in my computer system. But that's just me. Under the banner, again, it waives monitoring to make sure the system's running properly, my service provider exception. That doesn't waive the Fourth Amendment right. And if you've got acceptable use policies out in your corporations and your companies out there, don't think the cops can just come down and look at your system. Now, two aspects of things. Private company, private corporation, it's yours. You can consent to the cops to come in and look at your system. All right, government, hey, I am the cops, so it's a little bit different aspect. And if I'm providing services to the public, different animal too. And I've got the little DOJ chart here to say when you can voluntarily disclose information, when you can't. But in this case, the banner there waived the right to privacy, the expectation of privacy as far as workplace misconduct, violation of the use policy, monitoring to make sure the system's running. It didn't waive the right to having the cops come busting in and search the computer. This case has been certified for appeal in our system, and they're going to look at it to determine if there was even an expectation of privacy. The interesting thing on this one is, if you have an expectation of privacy, you've got to take the stand and say, yeah, I have an expectation of privacy. In this case, she never testified. They brought in a system administrator to testify as how the system worked, and the judge found an expectation of privacy, and that's what I think has a lot of Army lawyers, or actually this was a Navy case, government lawyers bent out of shape as far as that goes. Going back to a couple more things on what you can do with your use policies in defending your network, all right? Again, US v. Plush was a military case. The guy had a laptop and it cracked the screen on it. So he gave it to his techie to fix. Said, here, fix this. And as the technician fixed it, he found out that the recycling bin and the temporary internet bin was 40 times the size of a normal one. Well, what's in there? Well, a bunch of graphic images. He sees 4,500 different images in there, opens up 3, child pornography. So he does what anybody would do, he called the cops. Cops come over, they do what any good cop would do. They open up 100, because 3's just not sufficient. They need to open up 100. Then they go get the warrant. So they go through it, they look at it, and the case became again, did this individual, the system administrator, become a cop? And it said no. Let's look at the relationship. No relationship with the cops beforehand, was fixing the machine basically for the cracked screen, and through that process saw the misconduct going on there and then called the cops. U.S. versus Lazaga I like because it sounds like lasagna, first off. And it's also a professor at Yale University downloading child porn, so you gotta love that. A graduate student, of course, tells the system administrator, hey, I think I saw him downloading child porn. Now, this is an interesting aspect. I can't do this in the government, but the system administrator went and wrote a specific script to tell him when the professor's machine downloaded anything from the internet. And like right as he hits enter, he gets notification that the guy's downloading more porn. Goes walking by and he can see, I guess it was one of those doors with the windows in there, and you can see the shadow that's the professor in there. So he knows, okay, I've got this thing here. Now he keeps monitoring it and it keeps running. He tells the Yale University police about it. They have a meeting a week later. They bring in the state cops a week later after that. And the case kind of became, it's funny, at testimony, nobody remembered, did they tell you to keep monitoring? And no one could answer the question. It's like, no, I'd set this up. I don't remember them telling me to keep monitoring. And the court said, okay, I really don't have anything saying that you became an agent of the cops. Workplace misconduct under O'Connor versus Ortega, you can search. And oh, by the way, this evidence can come in with the cops, and they can use this to prosecute them for the child pornography. So again, limitations on what you can and cannot do. Port scanning. This is an old case, and the short of this one particularly is, if you're going to port scan, it is not accessing another computer, and it's not a violation of the Computer Fraud and Abuse Act. That's kind of the wireless aspect of life, and what is access is kind of a hot spot right now. When I talk to DOJ attorneys in DC and we start talking about what is access to someone's open wireless system, you start talking about, well, it's when information's being passed back and forth. And I'm like, okay, does that mean synac? Does it mean, and it's like they've come back and they've said, port scanning is not access to the computer. It's actually getting a connection established and getting what they've called meaningful information back. Now, what is meaningful? I don't know. Risk management again. If you want to be the first one to find out what meaningful is, by all means, have at it. This particular case, you had two individuals, two companies that were providing services to two different chief of polices of counties side by side. So what do they need to do? They need to hook up their 911 system. And the plaintiff in this case did the port scan on the defense system because he thought it was vulnerable. Obviously, the defendant got upset with this. Plaintiff gets fired, a big hoo-ha brewing on this. And basically the case, they cross-sue each other. And the court said, hey, no violation of Computer Fraud and Abuse Act. They didn't access the system. So port scan your little hearts out in terms of defending your system, at least from these facts, because there was the uncontroverted evidence in this was there was no slowdown in the system, there was no damage to the system. Those facts change one iota going towards damages or possible slowdown, you have just violated the Computer Fraud and Abuse Act. So, I'm sorry?
Don't port scan a computer in South Carolina. Actually, a state statute, it has includes violations.
Oh, for port scanning?
Yes.
Okay, because that's one of the other aspects that of things that are coming up. What I would commend to your reading is a couple of articles on Wi-Fi we're going to get to in just a second here. Good old versus Szymanski. Again, it's a general court-martial case for child pornography. Infinity Internet Incorporated voluntarily turned over information to the cops. Cops went down there and knocked on the door and said, hey, I need to get this subscriber information. They said, our guy who handles that's not here. He's out to lunch. Can you come back later on? So no order, no warrant, and he comes back later on, and the guy hands him all the information, usernames, subscriber information, sessions, without even asking for anything. And of course, to get out of this, they filed a motion to suppress, basically, illegal search. I have a Fourth Amendment and an ECPA right to the information you got. You didn't do it correctly. I should have this suppressed. And the court said, no, you have no Fourth Amendment right to subscriber information, so we're not going to suppress this. And oh yes, this was a violation of ECPA, that they should not have given you this information, but I send you back to Freeman versus America Online. As you're on your way to jail, you can sue the cops for having that information disclosed. So have a good lawsuit on your way to jail. Yes? Criminal aspect of life, okay? Two different aspects, criminal and civil. Criminally, violation of Computer Fraud and Abuse Act, access to a protected computer, which is such a broad definition. Any computer that affects interstate commerce, which is every computer, Again, you've got a violation of the Computer Fraud and Abuse Act, access to a protected computer. So you've got a criminal violation here. Next question, civilly. Do I have any damages? What can I get? You know, and that's another aspect. From a civil aspect, when I'm now going to take the statute, I'm going to sue somebody and collect money from it, because, you know, in law, that's all we do, is we want to sue people to get money. You don't sue poor people, you sue people to get money. No damages there, so basically I'm not going to get anything from that, on that. So the voluntary disclosure on this one, for our hero here, nope, the evidence is going to come in, and you're going to still go to jail. Now, I don't have this in your handout because I didn't want to step on DOJ's toes, although, again, I'm fortunate enough to work with them, and the gentleman, Paul Ohm, who would normally be here briefing, his wife just had twins, congratulations to him. So I put this in here, and this is the website you can go, which basically tells you, you know, when you can disclose and when you can't disclose information to the cops, and what is necessary to obtain that information. But it's on DOJ's website for cybercrime. You can find that. It's in their manual for search and seizures of computers. If you deal in this area, I would highly recommend that manual to you. It's online. If you call the Computer Crime Intellectual Property section at DOJ, they're such wonderful guys. I'm sure they'll mail you a couple copies of it. Now, we mentioned active response, and I get that question a lot. You know, my hard drive melted. It had to be you guys, because I was hacking away at you. You had, no, sorry, I don't, you know, my guys don't do that. From that, my active response are my cops. Now, you know, all services, Navy Criminal Investigative Services. For me, it's the CID. Specifically, it's the Computer Crime Investigative Unit. So I've got cops that investigate computer crime. Now, for private corporations, you've got the FBI. And you've also got private investigators that you can hire to come in and do your investigations and work with them. So that's kind of your active response. And your private investigators probably would fall under what my, you know, intelligence folks do, because if I've got a crime where they come at me from an IP address that's non-US, well, that's an intelligence, a possible espionage aspect. So my intelligence folks are going to get involved in that. A lot of questions come up in terms of commander-in-chief authority. This is going to kind of come back into the active response we're going to talk for you folks. The commander-in-chief authority really is the same thing as self-defense that everybody else has. If I've got a hostile act or hostile intent, I can defend myself. I can defend my property. I can defend people. And that's where this comes in. Now, the question becomes, when you're dealing with a computer, what's a hostile act? What's a hostile intent? And you know, without going in it, but citing several law review articles that are going on that analyze the current Bush administration's definition of the use of anticipatory self-defense. That is, you know, anticipatory self-defense. He stands up and pulls a knife and starts walking towards me. I don't have to stand here until the first plunge and then pull my 9mm and shoot him, okay? Anticipatory self-defense is, I can see the attack coming, I think he's planned it, and it's coming, I can defend myself. Well, when you're talking about hostile act or intent or use of force on the internet, how do you see that? How do you determine what, you know, a worm that's coming through, you know, denial of service, you know, that takes out one server. So these are all issues that need to be resolved and need to be resolved in the public sector when you're going to use an active response. I asked for a car, I got a computer. How's that for being born under a bad sign? Yeah, now I got to toss these all out. Come see me afterwards. I'll just give it. I'll leave them up here. That was an easy one. All right, prosecutions. Since we were here last time, Ms. Sabathia shows up because why? Well, because the poor gal, she pled guilty the last day of this conference. She was scamming. She was a clerk for her firm, used the computer to embezzle some $875,000. Believe it or not, she faces 5 years for the computer crime. She has not been sentenced as far as I can tell. Now we're talking about the wireless aspects of life on these things. Sausalito. Who here has heard of Sausalito? I like this case because it happened up in Southfield, Michigan, and I raised my voice there to wake everybody up to say, hi, we're back. This happened up in Southfield, Michigan in the Lowe's, it's a Home Depot store. Good old Timmons and, Bot Bill are driving around war driving, and they stumble across an open network at Lowe's in Southfield, right there at Southfield Road between 12 and 13 Mile Road, if you ever want to go up there and see it. And he finds out there's an open network there, and he logs in to check his email. And as he goes to transfer to surf the web, he finds out, oh, holy Batman, this is a private corporation, and it is not accessed there, so he logs off. Now, the one small problem with this is, and it's that classic situation that, you know, it's kind of like the Menendez brothers. You know, it's like Lyle and his buddy. It's like, you know, what should he have? Well, damn, I should have killed you too. I mean, you know, if you got two people, and if you find these things, somebody's going to know. So they drive away. Well, what does good old Bot Bill do? He goes and tells his buddy, Salcedo. They drive back 6 months later, hack into it, modify a TCP credit software on the system, which allows them to download all the credit card information that customers are using. And sure enough, Lowe's administrators kind of think something fishy's going on. They notify FBI. FBI comes out, and you know they stake out the parking lot, and you know they say they note the suspicious car. I do not know if the white Pontiac was standing there with a Pringles can and the arm hanging it up like this. Don't know, but they notice it. Follow them. Once I can follow them to, they watch what they do for a couple minutes. They drive off to a Little Caesars Pizza, then go take in a movie, and during that time, they search the computer, find out what the information is on there, and they arrest the two guys. Yes?
I was under the impression that the script that they used to try to capture the credit card numbers didn't work, so they didn't even get it.
I didn't hear that. I'm not debating that. I didn't hear that. From when I talked to them that, on this, I actually got that they didn't get as much information as they thought they got. So I'm not sure on that. The other problem on this one is I can't find out is we'll get to it, is I can't find out Timmons' sentence, the guy who showed up. He was facing, I think, 12 months probation, and I've talked to his attorney back and forth, but I haven't been able to get the sentence on him. Now, good old Salcedo, he gets sentenced to 108 months, which set a record. Bot Bill got sentenced to 26 months. Timmons was recently just sentenced, and again, I think he got probation on this one. The reason I like this is because, again, as I mentioned before, if you're planning on hacking your neighbor, you know, have a local attorney and on retainer, and you'll have to get them smart when you go into court. If you're planning on doing something really big, you want Ms. Granick in your back pocket, and I did like this because she was quoted in the case saying, using an open wireless access point isn't the same thing as using a computer illegally. Convictions for this type of things are possible where it's part of a larger crime. And she's talking about Timmons basically stumbling across it. I agree with her on that. We're going to talk about some aspects of the wireless internet. And I commend to you, if you can, I don't know that I've got this, I'm pretty sure I don't have these in the notes here. I would write down these two particular law review articles on here. They're excellent. It talks about war driving and the legal risks associated with it. I know Ms. Granick's going to talk about this more also on her presentation. Interesting aspect. Several states, Maryland, Delaware, Florida, Illinois, Michigan, Virginia, and Wyoming, have laws on the books that I've got my cable provider, you know, and I'm broadcasting open in my entire neighborhood because I've got 6 houses that back up to me, which you discover these things when you set up your wireless network. You're like, what the hell was I doing that for? I've got 5 neighbors who have wide open systems. Why am I paying for this? Because Virginia has a law that says if I use theirs and it violates their term of service, I can be prosecuted. So again, this is more of I've got a term of service that says it's like stealing cable from the cable company. And my term of service says, well, whatever my ISP is, you know, I will not run this as an open network and sublet to other folks. Hey, that can be a violation, and I can face some criminal charges for that. So, I'm sorry? That's what I was saying. This one I just added, so I would write down these particular cases. And again, if you search, the first one is Wi-Fi liability, potential legal risks in accessing and operating wireless internet. And the other one's whacking, joyriding, and war driving, roaming, use of Wi-Fi, and the law. They're both in the Santa Clara Computer and High Technology Law Journal. Again, they were excellent articles, kind of setting forth what your liabilities and what your risks are if your system's open.
Good question. Recently, DuPont Circle are setting up a open.
Wireless access point.
What does that do for everybody else who needs theirs open?
Well, you know, and see, that's, as far as the liability, you're really starting to get into kind of ISP law. And that's one of the things they've looked at to say, safe harbors. And if we have time to get there on these particular cases, one of Grokster's arguments in the Supreme Court case in the Ninth Amendment was, I'm just a conduit. They're just passing through me. So why should I be liable? And that is a safe harbor. If you're just passing through, you are not liable. Now, there's a certain aspect of whether you have knowledge or constructive knowledge, and that's one of the things they're saying with Wi-Fi is if you've got an open access point and someone comes up and they park outside your house and they start committing a crime, either downloading child porn or something, what's your liability on that? So far, they said, you know, again, no liability, you know, you're just, you know, you're the conduit for the activity, plus he's got the criminal intent for what they're doing with it. So far, no liability. Now, I would assume that when Ms. Granick speaks, she's going to start saying they might be moving down the road of trying to hold someone liable for this. Again, getting ahead of myself, one of the things we're starting to watch is, it's in here, Benjamin Smith, just arrested down in Tampa. Again, exactly what that Doonesbury cartoon was. He was sitting outside a guy's house using the internet, and they arrested him. Now, he was supposed to go to court around, I thought, July 11th. I haven't heard anything more on it, so we're waiting to see what comes out of St. Petersburg and the Tampa area to say, was that part of a larger criminal activity, which I gotta believe it was, but they charged him with unauthorized access to the computer. So that's one of the first cases we're watching down in Florida, and he was, I think, arrested in April and supposed to go to court in July. So we're checking out the liability for that. And if I didn't answer your question fully, please come up and see me after on this. Next case we're talking about, Jang, hey, he was going up to Kinko's up in New York and basically put keystroke logging information on all the computers. People come in, he was stealing usernames and passwords. Guy got 27 months, followed by 3 years supervised release. Trowbridge, we're going to kind of move fast so I can wrap this up and get you to lunch. This was operational digital gridlock. These guys were running the underground network. It was a Juarez peer-to-peer stuff. Good old Trowbridge had Movie Room, Ciccone had Acconin Alley, and good old Tanner had Silent Echoes. At any given time, they had 6.72 terabytes of films on it. Again, they're facing 5 years for running this. This was, DOJ was pretty proud of this operation, taking down these peer-to-peer networks. Greco. He started sending spam, instant messaging spam to myspace.com. And of course, he calls him up saying, I want to be your exclusive spammer, and if you don't, I'm going to release all the information on how to do this to everybody out there. You guys will never work again for the rest of your life. So he got arrested. He's facing 5 years potential for threatening and extorting a company when he hacked into him for doing the spims. Lido was half of the deceptive duo. These guys were hacking government sites saying, you're vulnerable, we're great Americans, you guys are vulnerable, please shore up your security for what we have going on here. He was sentenced to 4 months home detention and $71,000 fine. His buddy Benjamin Stark was the other half of it. He was sentenced to 2 years probation, and he has to pay 29 grand for hacking into the government computers on this. Manitavani. This was www.shadowcrew.com. DOJ is very proud of this. 19 individuals arrested, a 62-count indictment. Basically, this thing got so huge, they could not go undetected. Manitavani, who had his little handle of "Thank You, Please Die," and David Appleyard, which was Black Bag Tricks as well as Black Ops. Manitavani was the brains, and Appleyard was the brawn. They said, hey, we should get people who steal credit card information together with people who buy credit card information online, and we'll have a hell of a criminal organization, which is kind of good because good old Manitavani was a business student at Scottsdale Community College, so he was just taking that knowledge one step further. This had 16 Secret Service agents over running an operation, and of course, you gotta love what they did. You do what anybody does, you turn one of the guys close in the situation, and they got a guy, turn him, and he upgraded the website. And he told everybody here, I've upgraded the website, but what of course it did, it was a wiretap for the cops to be able to watch everything that was going on. They go to the ISPs with their orders properly done and signed by a judge, and they get the addresses. So now they're watching eyes on the computer, they're watching them at home. The guy they turn, they have say, you need to have a mass meeting online at 9 p.m. Eastern Standard Time, and sure enough, they did it. Cops bust down the doors, find these guys sitting at their computer. One guy jumps out a window, breaks his leg on the landing. He didn't run too far on that. But you're talking about people, 4,000 members in America, Brazil, Britons, Russians, and Spaniards. They go to trial in October if it goes. And oh, by the way, remember, everybody is presumed innocent until proven guilty. That keeps me from being sued. Parsons, the reason I like Parsons, he just released the worm on this one, and the reason I like this one is because the judge, every so often a judge will specifically say something, having worked for a judge, interesting. And this one, he was told by the judge, first off, his sentence was because he was 3 weeks past his 18th birthday. He had a history of mental illness, and his parents failed to monitor his activity. And the judge told him, no video games, no chat rooms, I don't want you to have anonymous friends, I want you to have real world friends. So, interesting aspect from that. This one I liked because it's the United States versus Alex Rodriguez. I kid you not. And it's in New York. Good old Alex Rodriguez, and no, it's not the baseball player, but Alex Rodriguez was selling pirated software. He operated a stand on East 14th Street. So if you're in New York, head East 14th. And he supplied another dude on East 23rd. So if you're there, ask for Alex, and you can pick up some software on this. And if you're thinking about doing time, or at least maybe doing something and not being on supervised probation afterwards, these two particular cases, Bellone and Lifshitz, talks about supervised probation release, non-access to computers, non-access to computer books or technology equipment, and monitoring equipment if you're going to have it placed on your system. In other words, we're going to look and watch everything you do, so they can't do that. Now, if you're going to do something and go to jail, though, King versus Federal Bureau of Prisons, King was in there for an unrelated crime. I think he was a drug dealer or something. And he wanted to get some computer programming books. And the warden said, no, I'm not going to give you that, because he could hack my system. And the judge said, first off, your system's a standalone system. He's not in there for a computer crime. And oh, by the way, he's doing it so he can learn programming, so when he gets out, it's actually kind of like rehabilitation, and you're preventing him from getting it. So no, so if you want to go to jail, do it for non-computer crime, and then you can get as many computer books as you want while you're doing it. The other aspect stuff just in. Good old Smathers and Dunaway. I guess Dunaway's a Las Vegas, is he here? Resident. This was the theft of 92 million AOL screen names. This is something that's going on. They expect them, both these guys to be looking at 18 to 24. Personal privacy and personal data seems to be the hot legislation that's going right now, because we're not going to get to the legislation that's pending. There's, I think, 11 or 12 different bills pending dealing with personal identity on this. Leahy's version just happened to be interesting. It was 91 pages. Best of luck reading that. REA, right on the heels of their Grokster victory, filed 784 more lawsuits, and 18 states are forming the Streamlined Sales Tax Project, which is collecting tax on internet sales. So they're pushing to get that in there. And that's Benjamin Smith, who's basically been charged with unauthorized access to a computer. That's the case I was talking about earlier. We've got to see if that's tied to some other computer crime as opposed to just access to an open Wi-Fi. We're moving along. Anyone? Who said the net? Where? Oh, it was Jack over there. So you got the net. This legal precedents. I put this up here as painful as that looks. That's the case caption for this case. This is MGM versus Grokster. You've got a lot of famous people in here. Again, Ms. Granick is the lawyer for Grokster in this. The Ninth Circuit Court of Appeals said, by all means, fine, no problem. The distinction on this one is, I'm going to move fast on this, was they were looking at the server. Centralized server, Napster, bad, can control that, bad boy. Decentralized server, where basically it's out there and you're just the software that hooks it up, good, lawful purpose. And that's what they looked at. Does this technology have a lawful purpose? Which was the Sony Betamax case. When Sony came out with Betamax, everyone's saying they're going to be downloading, or they're going to be copying movies, and people said, no. They're going to be recording Cheers at 9 so they can watch it at 10. It has a lawful purpose. And again, going through this very fast, the liability they were suing for in these cases was contributory liability and vicarious liability. Contributory liability, what this case really means, what the Supremes said was, all you peer-to-peer people out there who are doing this stuff, I can't get you. There's just no way. So if you're a facilitator of it, you're the guys I have to go after, and I'm going to find a way to get to you. Do not think for a moment, Bob Clark's personal opinion, that a lot of legal cases are not decided what they believe the decision should be, and then the decision is warped into that weird shape to make it happen. All right? That happens a lot. All right? Because in this particular situation, they can't get to the peer-to-peers. And they said, there's a little difference here. The appellate court said, there's a lawful purpose, Sony rules, see you later, Grokster, have a good day. The Supreme said, whoa, whoa, that's not an end to it. Sony does not overrule my common law doctrines, going back to unwritten laws, unwritten statutes, my common law, which says if you're going to be contributory liable or induce this action, you're going to be held responsible. The Supremes cited to a lot of internal memorandums from both Grokster and Streamcast that said, we want to target Napster. As soon as Napster falls, we want to be there. Well, there's your smoking gun if you're doing something like that that helps them along. So that was your peer-to-peer, basically the Supreme Court giving a shot in the arm to RIAA to go out and sue everyone who's doing this. I have a couple minutes left. I'm going to try to talk about US v. Councilman a little bit. This is a difficult case, and I know the attorney up at DOJ who's using this. Basically, the guy was a rare book dealer, and he also was an internet service provider. So when emails were coming in, he had a system set up that did a search, a query for Amazon.com. And as it came in, his copy went here, their copy went there. And the cops busted him for Title I, interception of emails. Now, he comes in and says, excuse me, there's the Title II, Stored Communication Act. And when it was coming into my system, it was in temporary storage right here before it reached the final recipient. And that's when I copied it. I did not intercept this. It was in temporary storage. And the court said, hey, you're right. This is not an interception. See you later. Now, this guy's sitting here smiling thinking, hey, this is great. I ain't going to jail. This is wonderful. But the rest of us are really dicked over, because what's good for him is good for the FBI. So if that be the case, cops don't need to go get a Title III warrant to intercept your emails, because they're all in temporary storage, because every time a packet moves, it's in temporary storage. Now, remarkably enough, DOJ's taking the appeal to go to the First Circuit, sitting en banc, I believe, to hear this appeal to say, Judge, we don't like this result. We want our cops to have to go and get a warrant to intercept this kind of information. So it's kind of a flip side. I put that out as a pro-DOJ message to say, see, they're not so bad. Sometimes they actually come and help. So we're keeping an eye on that particular case. Your other big cases are dealing with basically the subpoena enforcement aspect of life. This peer case, again, they were getting subpoenas for peer-to-peer. The fun aspect of this is you had the officer of the Commission of Baseball on this case. I thought it was kind of interesting. But it said trade associations cannot enforce subpoenas to internet service providers because in this peer case, they were under the safe harbor. They were basically just the conduit for the information moving back and forth. They couldn't control it, so they couldn't be subpoenaed. Same thing with that. Active response. When you're talking about active response, Kiko v. Brittany really they inherited a farmhouse, and the guy set up a spring-loaded shotgun. And his wife Ethel said, honey, don't aim it right here, aim it down at the floor. So he did. And when the guy came into the the house, opened the door, it blew away his right ankle. So when he stands on the right side, he's 5'6". When he stands on the left side, he's 6'4". Now, that's self-defense of personal property. Actually, this was self-defense of property. And what does this case stand for? They got sued, they had to pay. You've got to use reasonable force when you're going to do basically self-defense of property. And when we're in this field, you have the right to possess code that can, a worm. Mere possession of code, malicious code, is not a crime. I know people at DOJ who have it. United States versus Peterson is a case that basically says hacker skills, it's knowledge, skills, and abilities. The guy was elevated 2 levels by the judge for sentencing because he had certain skills that helped him commit the crime. So if I'm sitting here and I've got on my TurboTax a code that when you come in and steal it and download my personal information on your machine and it melts it, shouldn't I be able to do that? I mean, if you're a hacker and good enough to be able to break into my machine and you want to put my malicious code back on your machine, shouldn't I be able to do that? I didn't do anything. I didn't put that code on your machine. Now, again, risk management. Any of you who want to try that out, by all means, please get Ms. Granick's information before you leave. But these are the arguments and these are the things that we look at when we're talking about an active response. One of the other aspects that I'll leave you with is targeting. Be careful on your targeting for an active response. So these are all the issues that we deal with. I believe Ms. Granick is going to talk about these a lot more. As I mentioned, a lot of legislation going on right now. My favorite one is the Computer-Assisted Remote Hunting Act. You can no longer hunt bear with your computer on that. And there's the Whopper from. And final thoughts, my point of contact information for this. So if you have any questions, I will be up here right now. Again, carefully tread these waters as it's a very unsettled area. Thank you for participating.